Welcome to Immigration Quicktake. This is Ellie Rutledge Silver with the American Immigration Lawyers Association. Yesterday, the Supreme Court announced it had deadlocked with a 4-4 decision on U.S. v. Texas. Here to share what this means and what to look for next is Melissa Crow, Legal Director at the American Immigration Council. Melissa, thanks for joining me. First, what was the court's decision?
Well, Ellie, it was actually more of a non-decision than a decision. Essentially, the court came down 4-4, which means that the Fifth Circuit's decision stands and the preliminary injunction against President Obama's deferred action initiatives remains in place, at least for the foreseeable future.
What is the impact of this decision?
Unfortunately, this decision really leaves the immigrant community in limbo. People who would have been favorably affected by President Obama's deferred action initiatives and their loved ones are afraid that their families are going to be separated, and we really don't know what's going to happen in the coming months. On the upside, President Obama's initial deferred action initiative, that would be DACA 2012, remains in place, and this administration's enforcement priorities remain in place. All along, the administration has told us that individuals who would be eligible for expanded DACA and DAPA would not be subject to the president's enforcement priorities, and I think we have to hold the administration to that commitment. I think another implication of this decision is that we really have to redouble our efforts to ensure that legislative reform happens. At best, these deferred action initiatives would have been a Band-Aid solution that would have provided temporary relief from deportation for a fixed amount of time for the affected populations. And what we need is a permanent legislative solution that includes a legalization program and a path to legal status for most of the 11 million undocumented individuals in this country. This decision would have played out very differently if we'd had a fully functioning Supreme Court. Either if Justice Scalia hadn't passed away when he did, in which case I think we would have been in a much worse position than we are now, or if Judge Garland had been confirmed promptly by the Senate, in which case I think the decision could have played out much more favorably.
What are the possible next steps?
I think the best case scenario would be if the Department of Justice, or the interveners in this case, who are represented by MALDEF, request re-argument when we do have a fully functioning Supreme Court. That would have to happen in the next 25 days before the mandate issues in the case, and it's really not clear when that request would be decided. If rehearing were granted, we would get another bite at the apple, and I hope that the result would be very different than what we saw yesterday. What's not really clear at the moment is what's going to happen with the proceedings before Judge Hainan in the District Court of Texas. Even before the decision came down, Judge Hainan had asked the parties to appear before him after 21 days after the decision by the Supreme Court to propose a way forward and a joint scheduling order. So presumably they're still going to have to do that. There's also the matter of the kind of crazy order that Judge Hainan issued a few weeks ago, which orders the government to produce a list of individuals to whom they inadvertently granted 3-year EADs after the preliminary injunction went into effect. And which imposes some very rigorous ethical requirements on DOJ attorneys who were involved in this case. That hearing is scheduled for late August, and it's not clear whether Judge Hainan would proceed on either of those fronts if the government or MALDEF requests re-argument. Both the Council and AILA are going to continue watching this situation very closely, and we'll keep the AILA community apprised of developments as they happen.
Thanks, Melissa, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration and Lawyers Association.